Broadcast is now starting. All attendees are in listen-only mode.
And hello, everybody, and welcome. Happy holidays. Just so happens that today's topic for our webinar will be Holiday Ready Human Resources Happen, right? Just a little bit about today's presentation. First of all, my name is Marvin Schwartz. I'm the COO here at hrsimple.com, as well as American Chamber of Commerce Resources. Our total presentation should take about 60 minutes, give or take a couple minutes. You are able to get SHRM and HRCI credit for watching this webinar, and we will have codes that come up at the end. We'll also have the attorneys try to answer any questions that you have at the end of the presentation. So anytime during the presentation, there's a questions box on your screen. If you go ahead and enter your question in the chat box, we will try to get to all of them at the end of the webinar. And finally, after it's over, probably in a couple days, we will have this entire webinar on our YouTube channel, which is listed there at the bottom of the screen, youtube.com/HRSimple, where you can watch this webinar as well as all our other webinars that we have. At this time, I would like to introduce from the law firm of Constangy, Brooks, Smith & Prophete. Just so you know, they write our Georgia, the law firm writes our Georgia model policies and forms for hrsimple.com, as well as the upcoming New Jersey Human Resources Manual that will also be out in a couple months. Gary and Lori, they work in the Florida office, I believe, for Constangy, Brooks, Smith & Prophete. In the background here, I have a little bit of their bios up on the screen, and they are going to sit and take you through all the do's and don'ts of the holiday time. And without any further ado, let me introduce you to Gary and Lori.
Thanks, Marvin.
Good morning. This is Lori Manns, and I, along with Gary Wheeler, will be speaking to you about Holiday Ready Human Resources. I'll be speaking with you this morning about mainly decorations in the workplace and other sort of concerns that arise with respect to holidays, holiday parties, gift exchanges, and then to some extent holiday apparel and dress codes. And then towards the second half of our presentation, Gary Wheeler will be talking with you about wage and hour considerations, compensable time, those sorts of issues. Then we'll end our presentation about weather-related absences, which we've heard may be a concern today and in the coming days along some parts of the northeastern coast. So let's begin our discussion with kind of some legal background regarding Title VII of the Civil Rights Act of 1964, because when we discuss holidays in the workplace, from holiday decorations to holiday parties, the legal issues that frequently arise pertain to sexual harassment claims and those sorts of concerns, and then religious discrimination concerns. And certainly sexual harassment claims tend to be associated, as you might suspect, with holiday parties. And religious discrimination claims or accommodation claims tend to come up with respect to holiday decorations in the workplace, as well as holiday parties. And the federal law that's going to come into place with both private and public sector employers pertaining to both of these issues would be Title VII. And as most of you know, Title VII prohibits discrimination based on gender or religion, which can include the lack of a religious belief. And it also has an affirmative requirement with respect to religion that employers reasonably accommodate religious beliefs and practices unless doing so would present an undue hardship. It's important to remember that there may be state and or local laws that have provisions which differ from or have higher thresholds, higher provisions than Title VII, the federal law. So you should keep those in mind depending upon the jurisdiction that you're in. Our discussion today will focus on the federal law. In addition to Title VII, government employers, if we have any of those with us this morning, also have to be concerned with constitutional issues that can arise when we talk about holidays in the workplace. And the two main constitutional issues that come up in that context are First Amendment issues dealing with religious expression, freedom of expression, and the Establishment Clause. And I'll just touch on those very briefly. With respect to government employers and religious expression in general, government employers may not prohibit an employee from expressing his or her religion in the workplace unless doing so is based upon some sort of legitimate business need, and the rule or policy that the government employer is trying to enforce in prohibiting the expression is reasonably and rationally related to that legitimate business need. It's not overburdensome. Courts will often analyze those sorts of issues under what we refer to as a Pickering balancing test, which really just balances the restrictions on the expression with the employer's interest in promoting an efficient workplace. The Establishment Clause issue that I mentioned, that's a concern typically only to government employers, comes up particularly with respect to holiday decorations and whether the government is promoting or establishing one religion versus another. So holidays displays on government property, which we will discuss later in the presentation, bring up some of these constitutional concerns. But as I mentioned, Title VII does apply to both public and private sector employers, and that will be the focus of today's discussion. So you may know that the term religion, as it's interpreted under Title VII, is interpreted very broadly. And this is typically true of state laws which are modeled after Title VII. So not only does Title VII encompass traditional religions, or what is viewed as more traditional religions, like Christianity, Judaism, Islam, Hinduism, etc., but it also encompasses what can be viewed as non-traditional religions. You see many of the traditional religions reflected on the chart in front of you. You can see an increase just between 2016 and 2017 of those individuals who identify with a non-Christian religion. And it's important to remember that Title VII does include these less common religions. For example, you may have heard of the pastafarian religion. That's pasta as in carbohydrate, pasta, spaghetti. This actually was a real case where it was a civil rights case, but it's relevant in the employment context as well when we talk about what the term religion means under Title VII and what an employer's obligations are. And in this pastafarian case, there was a prisoner who indicated that he belonged to the church of the, quote, flying spaghetti monster. And as a result was seeking various accommodations, one of which, can't make this stuff up, was extra spaghetti and meatballs at mealtime. Now the court didn't look highly or favorably upon this claim that pastafarian was a true religion. It was actually based upon a spoof of religion that had been circulated at the time. But nonetheless, it's important because this case establishes that the religion at issue, in order to be protected under Title VII, just must be a sincerely held religious belief or the lack thereof of a religious belief. And so we typically recommend that employers not get into the business of questioning whether or not the religion at issue or the religious practice at issue is one that is sincerely held, or the practice is one that is a sincerely held tenet of the faith, because Title VII so broadly interprets those terms. And remember too, again, that Title VII can protect the lack of religious beliefs, which is important given, in particular, the increasing number of individuals in the United States who identify with no religious identity. You can see there in the chart in front of you that there's been an increase in the number of individuals who do not have a religious identity just between 2016 and 2017. And we would anticipate to see this number kind of tick up as the years go on. So let's take a look then at what types of holiday decorations are probably okay, and then some that may be, well, less okay. And when we discuss holiday decorations, we'll do so first with respect to those decorations that are tended to be thought of as secular, and then we'll talk about those that are tended to be considered religious in nature. So beginning with secular decorations, let's consider what may be a typical office holiday party. And let's consider an employer who's holding a potluck. And let's consider a potluck that's being held in the company's break room. You have a decorations committee, a food committee, and an overall planning committee for the employee potluck. And your decorations committee has brought in snowflakes, wreaths, a Christmas tree, and set the Christmas tree up with lights and various ornaments in the employee break room. There are also napkins with pictures of Santa, and then let's say someone brings in reindeer cookies. The potluck is voluntary, but it is held during working hours on site in the company break room. And let's say you have all of this going on in your break room where employees can kind of come and go throughout the day, and if they want, they can participate in get some food that's there, they can bring food, but they're not required to participate. They may need to go in the break room regardless because that's where they keep drinks, which they may want throughout the day. And let's say an employee who is known to be an atheist complains that he or she should not have to go into the break room and be subjected to these decorations. And again, these decorations are wreaths, Christmas trees, some lights, reindeers, some images of Santa. Well, according to the EEOC, their guidance manual indicates that these types of decorations are considered secular decorations, and that is consistent with the Supreme Court's case law on this point. And these types of secular decorations can generally be displayed in the workplace without running afoul of Title VII's ban on religious discrimination. It's also significant that the EEOC's guidance manual indicates that not only can an employer generally put these types of secular decorations out, but they also aren't required under Title VII to add any specific holiday decorations associated with various religions. So the secular decorations are generally going to be okay. Well, what about saying Merry Christmas? If we're talking about secular decorations, what about saying Merry Christmas? Is that secular or is it more religious in nature? And can your employees say this to each other? Or can it even be included on employees' email signatures? Probably yes is the answer. We don't give a bright line answer here, but probably yes. And one reason is because generally speaking, it would be difficult to establish that the use of the phrase Merry Christmas in and of itself constitutes some sort of religious discrimination, because it would be difficult to establish that the use of the phrase in and of itself impacts an employee's terms or conditions of employment. And it would be difficult to establish that the use of the phrase in and of itself constitutes harassment that interferes with an employee's work environment. You should also be aware of an interesting situation a couple of years ago where the EEOC represented an employee who was fired for saying Merry Christmas instead of Happy Holidays, as her employer had directed her to do. She said she was discriminated against on the basis of her religion, which was Southern Baptist, and that it was a sincerely held religious belief and a tenet of her religion that she should say Merry Christmas instead of Happy Holidays, and therefore the employer should have accommodated her on this basis. I was not able to find the results of that situation, but I think of that particular fact scenario, but I do think it's important to keep in mind that the EEOC, at least that time, took the position that this was a case worthy of bringing forward, and didn't believe that it was lawful for the employer to fire the employee on that basis alone. So can your employees say this to each other? Should you permit it? Probably yes. If you receive complaints about it, then you should deal with those on a case-by-case basis and look at, if you receive complaints, whether or not the conduct complained of really amounts to harassment. So let's talk about non-secular or religious decorations in the workplace. And as you can anticipate, these are the types of decorations that are more likely to lead to conflict, to trigger complaints and concerns under federal law, not just for private sector employers, but also for government employers who also have constitutional concerns to contend with. So when we discuss religious displays, we could be discussing most commonly menorahs or nativity scenes, but there are other commonly found religious symbols that can come up during the holidays. And when the EEOC, when the Commission considers the propriety of religious displays in the workplace, the Equal Employment Opportunity Commission looks at this in two different groups. And they consider first employee displays that employees themselves bring in that are personal to the employee, and then employer-sponsored displays. So we'll talk first about employee displays. These are the displays, for example, that the employee brings in from home. They may include little stuffed animals or little miniature statues that the employee puts up in his or her own workplace. And whether or not these are going to be permissible under Title VII depends upon the nature of the display itself, the location of the individual's workspace, and the type of workspace, whether it's private in nature, like a cubicle personal to the employee, or whether it's out in a more public area, and the other employees' and customers' response to the display. Displays that are in the employee's cubicle that other employees may only see in passing are probably going to be permissible. And in fact, those types of displays, prohibiting them may be a problem. And I want to give you an example that's included in the EEOC's guidance manual, or that's based on one included in the manual. Consider, for example, an employee who has a poster that says Jesus Saves right above the wall in her workstation. And consider an employer who orders the employee to take the poster down. The EEOC in its guidance manual says in this type of situation, if the employee has a sincerely held religious belief, which says that she should be displaying this poster, the tenet of her faith, the EEOC says she really should be able to display it. If it's in a private workstation and it's not impacting other employees and there's no other legitimate business reason for not being able to display it. But the EEOC contrasts that situation with a situation in which another employee has the same poster up in a lobby or public area that other employees have to frequent or members of the public have to frequent, and that triggers employee and public customer complaints. In that situation, the EEOC indicates that it's more likely that the employer would be able to prohibit the employee from keeping the poster up. So this same analysis can be used to analyze whether or not religious displays during the holidays are permissible when they're employee provided and employee triggered. And you would look at the nature of the display, the location of the workspace, and other individuals' responses. This same analysis would apply whether you're a public or private sector employer. I'll give you one more example before we turn to employer displays. There was a district court decision within the last few years where the allegations involved an employee, coworker, inviting another employee who was Jewish to a, quote, Christmas party, asking the Jewish employee to bring food, and having a nativity scene on her private desk in her private workstation. And in this situation, the court found that there was no discrimination or hostile work environment based on religion, because these allegations in and of itself did not rise to the level of either hostile work environment or discrimination. Well, if those things are okay with respect to employee displays, then what about employer displays? In our view, based upon our view of EEOC's guidance, their positions on this, and court decisions, as you probably can anticipate, employer displays of religious decorations are more risky. Not only do employers have to be concerned with Title VII, but employers in Title VII's prohibition against discrimination, but with Title VII's requirement that employers accommodate employee religious beliefs, And if employer displays are in public areas, which they tend to be, where all employees frequent, you're more likely to get requests for accommodation or complaints about those. So we generally recommend that employer displays be limited to the secular decorations that are permissible. If they're going to include religious decorations for private sector employers, we recommend that you consider including not just traditional Christian decorations, but also other religious symbols as well. And this is particularly important for public sector employers who have to be concerned with the establishment clause and cannot be viewed as supporting or endorsing religion. For those employers, in addition, we recommend that any religious displays be done in combination with secular decorations and other diverse decorations as well. So we find that this time of year is a good time to also remind employers and employees alike of what's permissible in terms of holiday attire and dress code policies. Of course, based on the background we've discussed with respect to Title VII's prohibitions against religious discrimination and some of the constitutional provisions that impact public sector employers, you don't want to be targeting holiday apparel based upon religion. Remember, too, that if you do have dress code policies in place, gender-neutral provisions are best. Gender-specific provisions are not per se unlawful, but this is an evolving area of the law where the EEOC has tended to focus more on those gender-based provisions. So if you have gender-specific provisions, make sure that they're not more onerous on one gender versus another. For example, the EEOC has given the example of an employer requiring female employees to wear costumes while not requiring male employees to wear similar costumes. And consider, if you do have gender-specific provisions in your dress codes, that if you have a transgender employee, you may need to consider modifying or working with the employee on those gender-specific distinctions. The degree of that requirement, those requirements rather, may depend upon the jurisdiction you're in, but that is a consideration. In addition to gender issues that arise, religious issues may also arise from the enforcement of dress code policies. So it's important to remember that Title VII's obligation to accommodate sincerely held religious beliefs extends to dress codes as well. And this can come, for example, in the form of modifying provisions to allow employees to wear headscarves and other religious garb. In addition, there are several examples within the past few years of the EEOC attacking dress code policies which require employees to wear pants only for safety reasons. There's examples of the EEOC bringing suit on behalf of female Pentecostal Christian employees whose religious beliefs dictate that they must either wear a dress or a skirt, and thus request accommodation from the pants only requirements. So if you have a requirement like that and receive a request for an accommodation from the pants only requirements, it's important that you engage in a process to determine whether and how you may be able to accommodate the employee's religious beliefs. If you can't, then you should feel very strongly that the reason you can't is because there's no other way to address the safety concerns at issue other than enforcing the pants only requirement. So in the context of what we discussed as legally permissible and then problematic as well, we've provided some best practices with respect to holiday parties in the workplace. If you're going to hold holiday parties in the workplace, and certainly nothing we have said should indicate to you or convey to you that you can't hold holiday parties in the workplace, but if you do so, be mindful of the decoration issues that we've discussed. Make it clear that the parties and any gift exchanges that occur during those parties are voluntary. This is particularly important with respect to some wage and hour issues that Yuri will discuss, some tort issues that I'll discuss in just a moment, but also with respect to any religious concerns that or aversions employees may have based on sincerely held religious beliefs to attending those parties or engaging in the gift exchanges. Consider the scheduling of your parties to ensure that you're not conflicting with any other religious holidays. Make sure you provide diverse menu options as well. So alcohol and the conduct that results from the consumption of alcohol at holiday parties is probably the #1 risk associated with those parties in terms of ways that employers can be liable for conduct at the parties. Generally speaking, through a theory of what we call vicarious liability, employers are liable for the wrongs that their employees commit if those wrongs are committed in the course and scope of their employment. And so when we're talking about holiday parties and what goes on at holiday parties by our employees, to consider whether or not what's done is in the course and scope of employment, courts would look at whether attendance at the policy is required, whether the party is held on site or during working hours and any of the time spent at the party is compensable, and then whether the party advances the employer's business interests. And if the answers to those questions are no, or the balance of the answers is no, then you're more likely than not going to be found not liable for a wrong committed by the employee. There are some good and bad to that if you're found to be not liable. Good because typically if there's an injury caused by an employee during the course and scope of employment, that would be covered by workers' comp, and there's really no question of fault. So if you don't have something that's done in the course and scope of employment, you're probably not going to be liable, but you may be fighting it out in that regard. Regarding intentional conduct, and that's where we get into discussions of sexual assault or battery, and sexual harassment as well can come up in this regard. If conduct occurs at holiday parties that touches upon these issues, typically liability is only going to result if the employer ratifies the conduct in some way. And an example of this would be if the employee, for example, knew of inappropriate touching going on at the holiday party and did nothing about it or did nothing to investigate, then the employer may be found to have ratified the conduct in some way. So we've talked about conduct in general at holiday parties and how that could be problematic for employers. But with respect to specifically alcohol, it can be particularly problematic. There are 2 cases frequently cited too, which arise out of employee alcohol consumption at parties. One involved an employee who drank at a voluntary after-hours business dinner. He got on the road in the wrong lane and caused a head-on collision. A federal court found that the employer was not liable for the injuries that the victim sustained because the accident was not within the course and scope of the individual's employment. It was a voluntary after-hours dinner. But contrast that with another decision by a circuit court where an employee attended a holiday party during the workday. It actually started at 8 a.m., you can believe that, and many employees became intoxicated during the party. There's some suggestion that employers, some of the management level employees in particular, were aware that employees had become intoxicated and did nothing. One of the employees left the party, ran a red light, and unfortunately killed someone in the accident. The victim's family sued, and it actually was found to be enough to go to a jury as to whether or not the employer was liable for serving alcoholic beverages, letting the employee drive, and whether there was some sort of vicarious liability on the part of the employer. So you can see the distinction there between an after-hours party that's voluntary, where assumedly there's no indication of impairment, and a business hours party where employers knew of intoxicated employees and did nothing. And those are sort of the factors that would come up if something happens, the unfortunate happens due to alcohol consumption. In order to mitigate any risk of A, injuries to others, and B, employer liability, if you serve alcohol at your holiday parties, we recommend that you have a third-party vendor serve the alcohol, for example, the restaurant, or if it's being held somewhere else, that you have another caterer serve the alcohol, that you enforce some sort of limitation on the number of drinks served, which is typically done through the use of drink tickets, that you encourage the use of designated drivers and actually make available alternate transportation, that you limit the duration of the party. We don't advise that you begin your parties at 8 a.m. and have alcohol available throughout the day, for example. And you can also stop serving alcohol 1 to 2 hours before the party concludes. That's another way to minimize risk. Certainly, if there's any indication that an employee is incapacitated, we recommend that you intervene. Obviously, underage drinking shouldn't be permitted. Many authors on this subject also recommend that you allow employees to invite their spouses, families, and that tends to have a positive effect on curbing inappropriate behavior, including overconsumption in alcohol. So also remember that conduct at holiday parties can serve as a basis for sexual harassment claims. There's literally thousands of examples of inappropriate behavior at holiday parties coming up in case law when individuals sue for sexual harassment. Usually, that type of conduct is in combination with other types of conduct, so it's not just one instance of inappropriate touching at a holiday party. But nonetheless, remember that it doesn't even have to be conduct that's related to a specific claim brought in court in order to come up. In fact, conduct at parties can be admitted as evidence at trial in support of other claims if it's related to the company's overall kind of opinion or overall way of dealing with inappropriate conduct by employees, then it can come up in other claims as well. And certainly, even though it's off-duty, inappropriate conduct at holiday parties can serve as a legitimate non-discriminatory basis for disciplining or discharging employees. So that concludes the portion of the presentation on holiday parties and decorations, but I'll turn it over now to Gary Wheeler to talk about some of the wage and hour considerations in that regard.
Thank you, Lori. This time of year, it's common for some employers to give employees either gifts or pay them bonuses, or perhaps both. So when it comes to paying bonuses to employees who are non-exempt under the Fair Labor Standards Act, or that is entitled to overtime if they work more than 40 hours in a work week, it's important to understand that certain payments may trigger an obligation to pay employees additional overtime compensation. The FSLA requires overtime pay to be determined using the employee's regular rate of pay, which includes all earnings paid to the employee during that work week. But the FLSA allows certain earnings to be excluded from the regular rate. Those are discretionary bonuses. And it's unfortunate that the term discretionary is used instead of by the Fair Labor Standards Act as opposed to some other term, because it has very specialized meaning in the FLSA context, and sometimes I'll be referring to as super discretionary. And what do I mean by that? Well, the fact that a bonus, or whether it's discretionary or not, has to meet certain strict requirements under the FLSA. So, and here they are, they set out on this particular slide, what makes a bonus discretionary. The fact that a payment is at the employer's sole discretion, that is, whether the payment will be made at all, is the first factor. The amount of the payment is at the employer's sole discretion. So the amount may be is entirely up to the employer's discretion, and that means that it's not a certain flat amount, and that means that it is not subject to a certain formula either, where somebody can have a couple variables and figure out what that payment will be given those variables. This determination is made by the employer at or near the end of the period, that is, near the, in this case, it would be the holiday payment that's at issue. And the bonus is not pursuant to any prior contract, agreement, or promise causing the employee to expect such a payment regularly. This funny thing about this particular requirement is that this particular provision would be, I guess, aggravated if there was a contract allowing for, quote, discretionary bonuses. So this is an actual example where there could be some confusion. An employer could have a contract that would allow an employer to pay discretionary bonuses, and the employer goes on to define how those discretionary bonuses would be determined if the employer were to pay one. But the very provision in the contract allowing for those discretionary bonuses would mean that it was not a discretionary bonus under the Fair Labor Standards Act. Okay. Bonuses provided for by a collective bargaining agreement are not discretionary. So that's a very clear example of one that's not discretionary. Okay. So gifts are very similar to discretionary bonuses. In fact, they may, in fact, be identical to discretionary bonuses. What is a gift? You'll see some of the same common requirements made at Christmas time or another special occasion as a reward for service. The amount's not measured or dependent on hours worked, production, or efficiency, and not paid to a contract. So there's very little, if any, difference between a gift and a purely super discretionary or FLA discretionary bonus. Okay, well, what about non-discretionary bonuses? Those are, non-discretionary bonuses are more likely to occur more frequently. There's nothing wrong with non-discretionary bonuses. Employers just need to be aware of the consequences that flow when you pay a non-discretionary bonus, and that is that there will need to be an examination of whether non-exempt employees are entitled to additional overtime compensation because of payment of non-discretionary bonus. Okay. So some examples of non-discretionary bonuses that we commonly see: it's announced to employees to get them to work more steadily or work more quickly or more efficiently, or to even just remain with the company, to be loyal and stay around for another quarter or another year. Attendance bonuses, so simply something that has a certain requirement threshold tied to attendance, is a non-discretionary bonus. Individual or group production bonuses, those would be team bonuses, or departmental bonuses would be an example of those. Bonuses based on the quality or accuracy of one's work, and bonuses contingent on the employees continuing in employment until the time payment is to be made. So there's a wide variety of factors that could cause a bonus to be non-discretionary. So, okay, so let's talk about how we calculate overtime or additional payment that may be due because of a bonus earned in a particular week. So here's an example of a $100 bonus in a work week for achieving a production goal. Okay, the employee, let's say, for example, worked 50 hours in that work week. And so in addition to their normal hourly pay, they were paid $100 in addition to that. So the bonus increased his regular rate by $2 an hour. So that would be, you take the $100 that was paid as a bonus divide it by the 50 hours of the work week, and you have your $2. And in this case, what we're determining is, okay, well, what additional time is paid for the overtime premium? And here, when the $100 bonus was paid, it was applied to all 50 hours, and so the straight time was paid. However, the time and a half, the half portion, still remains unpaid and will need to be paid to the employees. In this particular circumstance, it would be the $2 hourly rate that's applied for the bonus times 10 overtime hours. I'm sorry, it would be the 1/2 of the $2, which is $1 times $10, and that's $10 for the overtime. Okay, well, what happens if the bonus is earned over several weeks? And the bonus must be apportioned over all the work weeks for the period. But overtime is only due for work weeks, the period when overtime was worked. So again, this is better illustrated through an example. And let's say that an employee earned a bonus of $1,000 for a quarter or a 13-week period. There were 50 hours worked in 6 of those work weeks. Okay, so in 7 of the work weeks, there was no overtime. In 6 of the work weeks, there was. So there's no overtime in the rest of those work weeks. So calculating the overtime due on a bonus, you would take $1,000, which is the total bonus that was paid, divide it by the 13 work weeks and come up with a number, and divide that by 50 total hours. And then you multiply that times your half time and the total hours of overtime worked in a particular work week times the number of work weeks in which overtime was earned, and you come up with your figure of $46.15 that is due additionally as an overtime premium. So the lesson for employers here is to just budget accordingly. If you intend to pay these non-discretionary bonuses, just understand your obligation to pay the additional overtime premium when you pay it this way. Okay. What's a way around this problem or issue? It's not a problem if you account for it and you have a spreadsheet to work through how to make these adjustments to overtime. But you can avoid the problem by paying a percentage of compensation instead of paying a flat amount for a bonus. No additional overtime is due when the bonus is based on a percentage of total compensation, or at least their straight time plus legally required overtime. So the percentage bonus is paid, it's said to already include required overtime pay. So let's go through an example here. An employee earned $32,450 total in straight time and statutory overtime in a year. A bonus is given of 10% of this figure, or $3,245. So because a bonus was given as a percentage of total straight time plus legally required overtime, no additional overtime needs to be paid. So that is really the simplest way to make a non-discretionary bonus. Okay. All right. Well, switching gears, this time of year can be one challenging for employers because of time off requests. It can be a popular time to be off from work, and it's also unfair for a lot of employees because a certain small percentage of employees believe that this time of year is as good as any for abusing the FMLA and taking leave when it's not really needed. So the holidays just offer a more tempting opportunity for that small percentage of abusers to abuse leave time. So this can be especially frustrating for employers this time of year because attendance can already be thin and spotty during the holidays. So FMLA abusers are giving the gift that keeps on giving of workplace drama. So there are a few types of common FMLA abuse cases that we see when we review the case law where FMLA abuse is a reason for an employee's termination or discipline. Those include working a second job, shopping or running errands, failing to actually care for family members, taking or extending a vacation, partying or other recreational activities, and engaging in manual labor. Okay, so those are just a few of the types of abuses. Obviously, these types of abuse are not exclusive to the holidays, but I think we can agree this kind of abuse is probably disproportionately experienced during the holidays. So how can you as HR professionals respond to perceived FMLA abuse? Is the safest course of action for employers to just take it? What are the alternatives? Well, broadly speaking, there are two broad approaches to dealing with perceived FMLA abuse. One is to, what I would say, nibble or chip away at the problem, and then one other is to attack it head on. At first, this sounds like an easy choice. We would want to attack the problem head on, but it's not that simple. And please let me explain. The FMLA regulations offer a few courses of action that can be described as nibbling or chipping away at the problem. For example, if you have employees who seem to take off on Mondays or Fridays, or immediately before or immediately after holidays for their FMLA leave, if so, the FMLA regulations may offer employers the option of seeking recertification of the need for FMLA. Normally, recertification can be sought at most every 30 days. But if circumstances described by the previous certification on file with the employer have changed significantly, the employers may request recertification in periods of less than 30 days. But first, we have to be sure that the circumstances have changed significantly. Remember that the certification you have on file is only an estimate of the healthcare professionals anyway. So even if there's a pattern, the circumstances have changed significantly, the employee's doctor may, and some believe probably will, justify the pattern of absences. In other words, you may send the employee back for recertification and call attention to the healthcare provider and say, hey, these pattern of absences look unusual, they look inconsistent with your prior certification. And the healthcare provider may write back and say, well, yes, the employee really needs to be off for these reasons, and provide cover for the employee that you believe is abusing the problem. So this is why I call it nibbling or chipping away at the problem. It's a painstaking process to make sure that you're following the regulations in the first place, and then even if you do follow them properly, you may not find any basis for taking disciplinary action against an employee you believe is abusing the FMLA. So what about attacking the problem? Well, that is something that I want to discuss with you, which is called the honest belief rule. Well, what is it? What is the honest belief rule? Well, it's a judicially created defense, as opposed to the FMLA regulatory scheme, which I'm a fan of anyway. I like the FMLA regulations. I think they are actually one area where the government does a good job of laying out what employers are expected to do and what they can do. However, it does not provide a complete and total picture of all the employer's options. And this includes, or the FMLA regulations exclude, an honest belief defense, which is something that has been created by courts. And well, what does it provide? Well, if an employer takes adverse action, including terminating an employee, because they have an honest belief that the employee did not take the leave for the FMLA's intended purpose, then that is an appropriate defense under the FMLA, and it will justify an employer and is a useful defense against a claim of FMLA interference or discrimination. Okay, so this is the way of attacking the problem. You know, essentially, it's the employer saying we're not going to take it. The good news is that employers who utilize this rule have fared very well. A number of years ago, I did an analysis of 35 cases where an employer used this defense and the case was litigated. In 32 of 35 of those cases, the employer ultimately prevailed by relying on, in large part, the honest belief rule. So there's good news and there's bad news in that particular finding. One, the good news is that employers who have utilized it have fared well in litigation. 32 out of 35 wins in litigation is a very good percentage for employers. The bad news is that employers who utilized it often end up in litigation in the first place. As you know, litigation can be a very expensive process. So this brings me back to my original point, which is nibbling at or chipping away at FMLA views versus attacking it head on. I believe both have a place in the employer's toolbox. When you really suspect that abuse is happening and you believe that you have strong proof of it, attacking that problem may be worth it, especially if it could have the consequence of inviting other would-be abusers to take advantage of an employer's benefit and in a federal law. So, but chipping away at the problem may be a safer route and maybe be less likely to result in a claim of discrimination or retaliation. So, what have some of the employers used to help them determine whether or not FMLA abuse is occurring? Surveillance is one that I see in a large percentage of those cases. You're not required to use it, but you can use surveillance. If you do, we recommend you hire a reputable private investigation firm who make sure they follow all the laws with regard to surveillance. But many employees have been caught working in ways that are outside their restrictions or taking vacation when they should be recuperating from an injury or illness. So another key is just listening to the suspected abuser. The abuser may provide inconsistent statements regarding what they're doing, and this may take coordination with the employer. He may tell one supervisor one thing and another manager something different. So listening to the suspected abuser is another valuable tool. And I think that employers do better using this good faith defense when they're also employing the other things, the other regulatory tools that are available to them, including requiring frequent recertifications because employees understand that you have a strong handle on both your obligations and your rights as a FMLA employer. Okay. All right, well, switching gears, we wanted to talk about one last issue that crops up this time of year, and that's inclement weather practices and policies. And I figured the best way to jump into this particular topic was with a quiz. So here is a particular quiz for you. Okay, which of the following is not permissible under the Fair Labor Standards Act when there is inclement weather? Okay, so which of the following of A, B, C, and D is not permissible when there's weather that, there's bad weather, whether it be bad wintry weather or in the case of holiday weather or hurricane weather in earlier in the fall? A, close the facility and do not pay non-exempt employees for hours they were scheduled to work. B, close the facility and do not pay exempt employees for hours they were scheduled to work. C, keep the facility open even though it is unlikely the employees can get in and do not pay non-exempt employees. And D, keep the facility open even though it is unlikely that employees can get in and do not pay exempt employees who can't make it. Okay, so what's the answer to this? And it's actually B. If you close the facility and do not pay exempt employees for hours they were scheduled to work, that is a violation of the Fair Labor Standards Act. In other words, that ruins the exemption. Exempt employees should be paid their weekly salary when they're, that weekly salary shouldn't be dependent on the quality of work that they perform in that work week. And so an employer, in this case, is not allowing an exempt employee to work their scheduled work week and is penalizing them by not paying them their full weekly salary. And so that would be a violation of the Fair Labor Standards Act. Okay, so just wanted to cover a little bit more of that, about the basic rule. When work closes because of inclement weather, exempt or non-exempt employees are treated differently under the FLSA. If the company closes for weather-related reasons, non-exempt employees are not entitled to pay. It's simply not work time. An employer can allow non-exempt employees to use accrued paid time off to cover their absences. If PTO is not available, the time off is unpaid. Now, the employer has a business decision or a choice. There's nothing wrong with paying non-exempt employees for time off due to bad weather, and it may be a good morale builder, but it's not required. The employer might, for example, provide a fixed number of paid inclement weather days in a year. As for exempt employees, however, the application of weather-related absences is more complicated. In the case where an employer is open for business, but an exempt employee chooses to stay home, that employee is not entitled to pay for that day because she chose to remove herself from the workplace for personal reasons. If the employer has a PTO policy and the employee has accrued time, she can use that PTO to cover for her absence. In the event there is no accrued PTO time available, the employer can reduce the employee's pay for the absence in full day increments without violating the salary basis test for the Fair Labor Standards Act. However, when the employer decides to close for weather-related reasons, the employee's full salary must be paid for the week, even though she may not have worked the full work week. In this scenario, the employee is available to work, but it is the employer who has made the work unavailable to the employee. And that's why B is the correct example in this scenario. Well, that concludes both Lori and I's prepared remarks, and Marvin, we're open to taking any questions if anybody in the audience has any.
I've seen a couple questions. One, it says, I've been calling it a Christmas party for all these years. Should I not be doing that and calling it a holiday party? Is there a problem?
So this is Lori, and I'll address that question. I'll tell you, generally, no, and it's for the same reasons that I mentioned when I was covering whether or not saying Merry Christmas in and of itself would be a problem. And I think it's also been addressed by at least one court, to my knowledge, in the context of the case I mentioned, where an employee invited another employee who did not observe Christmas to a, quote, Christmas party. So in and of itself, we do not view that as unlawful. As far as a best practice, when you're advertising those parties, if they're employer-sponsored parties, a best practice would be to instead refer to it as a holiday party. But the mere use of the word Christmas when describing the party, we do not believe constitutes unlawful discrimination.
Okay. The other question I got was regarding drinking at holiday parties that are on site. Is there legally some kind of, you talked about drink tickets, I guess is what this is referring to. Is there legally like a set amount of what is too much alcohol, or is there some kind of formula or something that how much you should serve?
So we can't give you a precise formula as far as how much you should serve, because whether someone becomes intoxicated is so dependent upon the person's size, if their toleration, if they drink more frequently than others, they may have a higher toleration. But when you utilize something like drink tickets or a system like that, and you limit it, depending on the length of the party, for example, to 2 or 3 drinks, you have more control over what an employee consumes than if you don't use a system like that. So I think, something like 2 or 3 drinks, for example, at your typical evening type party would be reasonable.
Okay, and the last question that I saw says, in these volatile times, are employers, when they have parties, it talks about people drinking too much and sensitive topics and politics that are discussed at parties. Are employers responsible for having some kind of security, or are they held liable if they don't?
Wow, good question. So I'm going to, I guess, assume that is referring to holiday parties and whether or not employers need to ensure the safety of their employees at holiday parties. I think that the duty to ensure your employees' safety is not the same as it would be for the traditional workday. As long as the holiday party is voluntary, for example, I think the duty owed to your employees, if there is one, is less in terms of the burden on the employer. So I think just reasonable steps. If you're gonna have a holiday party at an unusual location, there may be some additional risk you assume. But if you're gonna have it at the traditional location, like a restaurant or a conference center, or even on site, then I think just reasonable steps that you would take with any sort of employer-sponsored event would apply. There's no specific duty to have a security guard, etc.
Okay.